Hello, this is Seamus Boyce, and this is the latest episode of my professional development series on education law trends. This is episode 7 regarding the revised Title IX regulations. So the latest update on me is this is the first episode that I am recording after I have joined the Kroger, Gardis, and Regas KGR law firm as a partner. So moving forward, the remainder of this professional development series will be through my partnership with KGR, and looking forward to working with this law firm and continuing on with my career in education law. This is same cell phone number, same phone number that you have for me, just have a new email address. So you can continue to use a prior email address that you had when I was working through my professional corporation. However, this is my new KGR email address. So to orient you to where we are in the series, we have now completed the debrief from the 2020 Indiana General Assembly session, and for the remainder of the series, we're covering various issues. I think the one exception of us not covering the bills or legislation from the General Assembly session, we still are going to cover 1003, HEA 1003. So that will be in a future episode. And just a reminder that while the professional development series is being released, we're continuing to have the Monday office hours. So a good time for you to ask questions and discuss the content of the professional development series, and we'll have continue to have a few more guests join us for those office hours. The typical disclaimers that I have provided to you in prior episodes, and particularly important for this episode because of the content being so new, and there is going to be new guidance and perhaps future changes to these regulations. So please do make sure that you're following these disclaimers. And with that, I will warn you that the special disclaimer for this episode is that we are going to have a fire hose of information coming at you because there's a lot to unpack with these new regulations. So I'm going to do the best that I can. I'm not going to cover every minute detail, but we'll cover the main items from these new regulations. And to give you a lay of the land, we'll go through the table of contents of what we're covering in this episode. First, going to give you a background of where these revised regulations came from. Going to talk about the effective date because that's very important. When do these regulations go into effect? Going to break down the new definition of sexual harassment that is included in the Title IX regulations. Going to talk about the new provisions on the Title IX coordinator. And we're going to address the policy and notice requirements that are in the new regulations, the reporting allegations of sexual harassment provisions, as well as breaking down who's a complainant, who's a respondent. Going to talk about the location limitations for these Title IX regulations as applied to the K-12 environment. Going to talk about the educational institutions' requirements for a response. What are the general response requirements, as well as when there might be the requirement to have a emergency removal or putting someone on administrative leave. Now we're going to go to the second column here. Lots of information, I know. We are going to talk about the formal complaint process, the basic elements of the formal complaint process, which include the written notice, dismissal, consolidation of claims, breaking down the investigation, hearings, the determination of responsibility for sexual harassment, the appeal process, informal resolution provisions, record-keeping requirements, and finally, requirements in regards to retaliation. We'll conclude with some high-level suggestions for you in your checklist of compliance. So we are going to jump right into the background. So the U.S. Department of Education, via the OCR, the Office for Civil Rights, has now amended these regulations, and they're found in 34 CFR Part 106. I'm not going to go through all of the different regulation provisions in this recording, but many of them are referenced in the materials. The existing regulations on topics such as athletic participation, employment, and single-sex education were not addressed by the final rule that came out of the OCR. Prior to this most recent amendment to the regulations, the Title IX regulations didn't specifically refer to sexual harassment. However, we look at several different cases, including the Gebser and the Davis cases, that establish the definitions and standards that are commonly used in the context of adjudicating allegations of sexual harassment in educational institutions, while the OCR's non-binding Dear Colleague letters would set out the standards for liability for recipients of funds. Now, the Title IX regulations define sexual harassment and establish detailed procedures for how educational institutions are subject to Title IX and referred to as recipients. So anybody that receives federal funds subject to Title IX, how they must respond to allegations for sexual harassment. So that's the background. Now, the effective date. This is important because there had been concern that this was going to, these regulations would come on board and you would be immediately responsible for compliance. You'll see here on this slide some background that why we don't have an immediate effective date. And the primary reason identified is in regards to COVID. And quoting the department, that they recognize the practical necessity of allowing recipients time to plan for implementing the final regulations regarding the extent necessary time to amend their policies and procedures necessary for compliance. So you got a short period of time here because these requirements go into effect on August the 14th of this calendar year 2020. So you basically have summer, in addition to all of the other issues that you're dealing with in regards to COVID, to come into compliance with the new regulations. And with that, I would imagine most of you are feeling like the slide presents here as you're a bit of a deer in the headlights as to how are you going to get all this accomplished. And it is a lot, but we're going to break it down and do the best we can to be in compliance by August the 14th. First off, the definition of sexual harassment. This is been included in the regulations, and it's three pieces could provide for sexual harassment under the regulations. Number one, if an employee of the recipient conditions the provision of an aid, benefit, or service of the recipient on the individual's participation in the unwelcome sexual conduct. This is also referred to as the quid pro quo sexual harassment. So that's one way for there to be sexual harassment. Number two, if there is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. So let's break that down just a bit. Some key words and phrases here. Unwelcome. The person has to identify it as an unwelcome conduct that they did not participate in willingly. The next phrase, by a reasonable person. So this is not a subjective standard of the parties that are involved. This is an objective third-party standard from a reasonable person standard, and that it's severe, pervasive, and objectively offensive. This is a change from guidance that had previously been provided by the OCR, and more difficult to require. The next piece is that the conduct has to effectively deny the person equal access to the recipient's education program or activity. This is also a more difficult standard to meet than had traditionally been provided and guided by the OCR. The conduct has to effectively deny the person equal access. So that is where a vast majority of the allegations may be, is in the second provision. But the third provision is specific violations under federal law, as defined by federal law: sexual assault, dating violence, domestic violence, and or stalking. Those are all provisions that can satisfy the definition of sexual harassment. The next provision that we're going to go run through is in regards to the Title IX coordinator. Title IX regulations have always required recipients to designate an employee to coordinate the recipient's efforts to implement the law. The final rule, however, that goes into effect in August, requires that recipients not only designate but also authorize this individual to coordinate the recipient's compliance efforts. The rule also requires the employee be known as the Title IX coordinator. You have to not only identify somebody as a Title IX coordinator, but you have to take official action to authorize that person to coordinate the compliance for the recipient or the educational entity. So a lot here, and you're going to see some slides have a lot of information packed into them, but I will break them down for you. The next provision breaks down the policy and notice requirements. And so several things here. One, it removes portions of existing regulation regarding dissemination of policy. Most of the prior regulation substance has been moved to a different provision, but just a warning that recipients should be careful to review their notices and publications to ensure that they're compliant. Next item, the regulations require a recipient to provide notice of its non-discrimination policy and grievance procedures, including how to file or report sexual harassment and how the recipient will respond to the following groups: applicants for admission and employment, students, parents, or legal guardians, union or professional organizations holding agreements with the recipient. So specific groups that need to be informed of the policy and the grievance procedures. The regulation also requires that the notice to these same groups include the Title IX coordinator's name or title, email address, office address, and telephone number. So a couple of the new provisions there is that has to identify that, allows that person to be identified by title and not necessarily name, to allow that policy not to have to be revised as frequently. But it does have to now include the email address of the person involved, of the Title IX coordinator. Next provision, regulation requires a recipient's notice of the non-discrimination to state that the recipient does not discriminate on the basis of sex in the education program or activity that it operates, in that it is required by Title IX and its regulations not to discriminate in such a manner. The notification must state that the requirement not to discriminate in the educational program or activity applies to employment. The notice must also indicate that inquiries about the application of Title IX and its regulations may be referred to the Title IX coordinator or the Assistant Secretary of OCR, or both. So those are all provisions that need to be in the notice. Realize that those that get subpart C, those that are subject to subpart C of the regulation must also provide notice of the requirement not to discriminate in admissions, and realize that Part C does not apply to elementary and secondary schools. Finally, on this slide, realize that recipients must publish the notice of non-discrimination described previously, and the Title IX coordinators' contact information on their websites and any handbook provision in the groups listed above. So very important that this information is included in various sources, including the website and any handbook. Next slide addresses the reporting allegations of sexual harassment. Any person may report sex discrimination, including sexual harassment, regardless of whether the person is the alleged victim of the reported conduct in person, by mail, by telephone, or by email using the contact information listed for the Title IX coordinator, or by any other means that results in the Title IX coordinator receiving the person's report. Such report may be made at any time, including during non-business hours, by using the telephone number or the email address or the mail, or by mail to the office address listed for the Title IX coordinator. Now, specific to K-12 educational institutions, the regulation defines actual knowledge of sexual harassment as notice of sexual harassment or allegation of sexual harassment to any employee. So this was one of the pieces that was under consideration. The OCO chose to expand the employees who would trigger an official response by the Title IX coordinator, and therefore require that of receiving the information of any employee because of several things. One, to ensure consistency with mandatory child abuse reporting laws and the risk that an adult who targets a young child may pressure them to stay silent. So the OCR opined that it is quote unquote unreasonable to expect young children to seek out specific employees for the purpose of disclosing Title IX sexual harassment. So one of the major pieces to emphasize is in your updates, in your training, it's very important for all staff and employees to realize that they have a role in receiving information about allegations of sexual harassment. All educational entities need to have a process to ensure that that proper information gets filtered appropriately within the organization. Next provision talks about the complainant and respondent. Who are the complainant and respondent? Defines a complainant as a person who is alleged to be the victim of conduct that could constitute sexual harassment. A complainant may file a formal complaint with the Title IX coordinator by mail, email, or other method made available by the recipient. At the time of the filing of a formal complaint, a complainant must be participating in or attempting to participate in the educational program or activity of the recipient with which the formal complaint is filed. And the Title IX coordinator may also sign a complaint which does not make the Title IX coordinator a party in the grievance process. On regards to the respondent, the final rules define respondent as an individual who has been reported to be the perpetrator of conduct that could constitute sexual harassment. Now, coming back to the piece about the Title IX coordinator's role, the regulation does not authorize a third-party reporter to file a formal complaint. The OCR had commented to try to make clear that a Title IX coordinator may sign a complaint, thus triggering an investigation in order to ensure that the recipient does not respond to sexual harassment with deliberate indifference. So in their view, in some cases, this may entail implementing a formal grievance procedure over the complainant's objections. And by defining the complainant as a person who is alleged to be the victim of sexual harassment in any event, the regulation ensures that the alleged victim has access to supportive measures and receives written notice of steps in the grievance procedure, even if he or she is not a willing participant. So that will be something that schools will need to figure out. And one of the more interesting developments here is that you could have a complaint process that is initiated where the complainant doesn't want to sign the actual complaint, and the Title IX coordinator may have to sign the complaint to get the process moving. On to the issue about K-12 location limitations. So for K-12 recipients, the regulations define an education program or activity that's subject to Title IX as including any location, event, or circumstance over which the recipient exhibits substantial control over both the alleged harasser and the context in which the harassment occurred. So a few different phrases to unpack there. So we're talking about a location, event, or circumstance, so it doesn't necessarily have to be school property, but the school has to have substantial control over the harasser and the context in which the harassment occurred. The a comment on this one that came from the OCR that isn't in the rule itself, but helps us understand it, states that the definition of sexual harassment does not make sexual harassment dependent on the method by which the harassment is carried out. The use of email, the internet, or other technologies may constitute sexual harassment as much as any use of in-person, mail, handwritten, or other communications. So I think the OCR attempted to try to clarify, but there's still quite a bit of gray area about what jurisdiction there will be. And there will be, I think the clear intent is to try to more narrowly define the issues in which Title IX applies, in which the school has responsibility, but there is still going to be quite a bit of debate about where that line ends. In regards to the educational institution's response, the regulation discusses the general requirements for responding to a notice of sexual harassment separately from the required procedure for responding to a formal complaint of sexual harassment, defined as a document filed by a complainant or signed by the Title IX coordinator alleging sexual harassment against the respondent and requesting that the recipient investigate the allegation of sexual harassment. So what are some things to consider in regards to the general response that has to occur when we've got this complaint of sexual harassment? The school, the recipient, must respond promptly to that actual knowledge of sexual harassment in the program or activity of the recipient against the person in the United States in a manner that is not deliberately indifferent. So this provision is now in the regulation, and it essentially adopts this Supreme Court standard from these Gebser Davis cases, stating that the recipient is deliberately indifferent if its response is clearly unreasonable in the light of known circumstances. So that's the standard that the school is going to be held to of what their responsibility is. The recipient's response must treat the complainants and the respondents equitably by offering supportive measures to a complainant and by following a grievance process before imposing any disciplinary consequences or sanctions on a respondent. So a couple pieces to clarify there. One, the rule defines supportive measures as non-disciplinary, non-punitive, individualized services offered as appropriate and without charge to a complainant or a respondent before or after the filing of a complaint, or where no complaint has been filed. Some examples of supportive measures include actions similar to what has been referred to as interim measures in prior guidance. And so these would be counseling, course modification, schedule changes, and increased monitoring or supervision. The OCR does emphasize that supportive measures should be designed to restore or preserve equal access to the educational program or activity without unreasonably burdening the other party. Final provision in regards to the general response expectations, the regulation requires the Title IX coordinator to promptly contact the complainant, who is the alleged victim, to discuss the availability of supportive measures, consider the complainant's wishes with respect to the supportive measures, inform the complainant of the availability of supportive measures with or without the filing of a formal complaint, as well as explain the process for filing the formal complaint. So those are some of the general requirements of that Title IX coordinator. So while the general theme of the regulations is to have some pretty detailed process before a determination is made about sexual harassment, there are some emergency removal and administrative leave provisions. The rule clarifies that the regulations do not prohibit immediate removal of the respondent from the educational program or activity on an emergency basis, provided that the recipient conducts an individualized safety and risk assessment and determines that emergency removal is necessary in order to protect a student or other individual from an immediate threat to physical health or safety. Then that key word is physical. The school must provide the respondent with notice and an opportunity to challenge the decision immediately after the removal. And in regards to that physical word included in the standard, emergency removal is not appropriate under the regulation to address emotional or mental health needs. And rather, the regulation would require those to be addressed through the supportive measures. The emergency removal does not modify any rights under IDEA, special education law, Section 504, or the ADA. The Title IX regulations don't trump other federal laws like special education law. And also, the regulations do not prohibit placing an employee who is a respondent on administrative leave while the grievance process plays out. So the formal complaint process, let's break that down now. And these are coming from the regulation. In response to the filing of a formal complaint, the recipient must follow the procedure that complies with several basic components. One, they have to treat the parties equitably by providing remedies to the complainant, and a determination of responsibility against the respondent has been made, and following a grievance process before imposing any disciplinary sanction or other action that are not supportive measures against the respondent. So remedies, may include the same actions described as supportive measures, but remedies need not avoid punishing or burdening the respondent. So these regulations are intended to be helpful to all people that are in the process, but that doesn't mean that the respondent is prohibited from being suspended, expelled, or having other type of traditional discipline. Another component is that it requires an objective evaluation of all available evidence, both inculpatory and exculpatory, and that it prohibits credibility determinations based on a party's status as a complainant, respondent, or witness. The next basic element of the complaint process is that it requires any person designated as a Title IX coordinator, investigator, decision maker, or any person designated to facilitate an informal process not to have a conflict of interest against complainants and respondents generally, or against the particular complainant or the respondent. So these individuals who are prohibited from having conflicts must also receive training on the definition of sexual harassment, the scope of the recipient's education program or activity, how to conduct the investigation and the grievance process, including as applicable hearings, appeals, and informal processes, and how to serve impartially. The investigators must receive training on how to prepare an investigation report, and the decision makers must receive training on any technology to be used at a live hearing and issues of evidence and questioning, including when questions about a complainant's prior sexual history or disposition are relevant. Training must promote impartial investigations, and adjudication of formal complaints must not be based on sexual stereotypes. So there's a lot to address here, and there will be plenty of training requirements for the people that are involved in this process. The next basic element of the formal complaint process is that there has to be a presumption that the respondent is not responsible for the alleged conduct until a determination has been made at the conclusion of the grievance process. It also has to include reasonably prompt timeframes for the conclusion of the grievance process, including a process for temporary delays based on good cause, for example, law enforcement being involved in the allegations, absence of a party, a witness or advisor, translation or accommodation needs. But those have to be with written notice to both parties explaining the reason for the delay. The next element of the basic formal complaint process is that requires the description or list of possible disciplinary outcomes and remedies that may be implemented following a determination of responsibility. More basic components of the formal complaint process has to include the procedures and the permissible reasons for appeal by the respondent or a complainant, has to describe the range of supportive measures available to the complainants and the respondents. It has to not require or allow or use evidence or questions that constitute or seek legally privileged information unless the privilege is waived, and has to indicate whether the recipient uses a preponderance of the evidence or clear and convincing evidence standard to determine responsibility. This is a big front-end decision to be made when updating your policies and your practices. And the most important thing when making your determination is being committed to using it consistently. So the recipients must use the same standard of evidence for all formal complaints, including complaints against employees. And to give you a visual, think of the preponderance of the evidence standard as the lower bar in order to establish whether sexual harassment occurred and the responsibility of that sexual harassment. And the clear and convincing standard as the higher bar. That's going to be more difficult. More technical than that, but that is at least one visual to think about the different standards. Next provision has to do with what needs to be included in the written notice for the formal complaint. So once that formal complaint is received, the recipient must provide written notice to all known parties in a sufficient time to give the respondent time to prepare a response before an initial interview. That written notice must include the notice of the grievance process, including any informal resolution process, the notice of the allegations, including sufficient detail, for example, names of the known parties, the conduct alleged to be sexual harassment, and the date and location of the conduct, if that's known. All this to allow the respondent to prepare a response. The statement the notice has to include a statement that the respondent is presumed not responsible for the conduct and that the responsibility will be determined at the conclusion of the grievance process. It also has to include notice of the party's right to have an advisor who may be, but is not required to be, an attorney, and to inspect and review the evidence. Finally, the notice has to include notice of any provision in the code of conduct that prohibits knowingly making false statements or providing false information in the grievance process. If in the course of the investigation, the recipients decide to investigate allegations about the respondent or complainant that were not included in the original written notice, a notice of those additional allegations must also be provided in writing to the known parties at the time. Next provision in regards to dismissal. The complainant must be dismissed. The complaint must be dismissed if the allegations would not constitute sexual harassment as defined in the code, even if proved. If it did not occur in the recipient's program or activity, or did not occur against a person in the United States. So if any of those three provisions apply, the complaint has to be dismissed by the school. The complaint can be dismissed or may be dismissed, so the recipient has the discretion to dismiss if the complaint notifies the Title IX coordinator at any time that he or she wishes to withdraw the complaint or an allegation, if the respondent's enrollment or employment ends, or if the specific circumstances prevent the recipient from gathering evidence sufficient to reach a determination. So one piece that the OCR comments on is that they allude to the passage of several years between a formal complaint and the alleged conduct, or a complaint ceasing to cooperate with the grievance process as examples of specific circumstances where a school may want to dismiss the allegation or dismiss the complaint. If the recipient dismisses the complaint, written notice must be promptly provided to both parties simultaneously, including the reasons for the mandatory or discretionary dismissal. Next provision is in regards to consolidation. So the rule provides wide latitude to consolidate formal complaints against more than one respondent by more than one complainant against one or more respondents, or by one party against another party, where the allegations arise out of the same facts or the circumstances. So that's going to be the key. Is it basically the same circumstances that you're duplicating efforts on the investigation? You can consolidate those investigations. The next provision is in regards to the investigation requirements. The regulation requires that when investigating a complaint and throughout the grievance process, a recipient must ensure that the burden of proof and of gathering evidence rests on the recipient rather than the parties, except that certain treatment records cannot be obtained without voluntary written consent from the party or the parent. So the school's responsibility is the one to gather the evidence, and it's not upon the parties to provide the evidence. Next provision in regards to investigation require the requirement that there'll be an equal opportunity for the party to present witnesses and evidence, that there's not a restriction on either party's ability to discuss allegations or gather and present evidence, that the parties with the same are provided the same opportunity to have others present during interviews or other related proceedings, including an advisor who may but is not required to be an attorney. The requirement to provide to a party who is invited or expected to attend written notice of the date, time, participants, purpose, and location of the investigative interview, hearing, or other meeting with enough time to allow the party to prepare to participate. Next provision in regards to investigation is the requirement to provide both parties and their advisors, if any, an equal opportunity to review all evidence that is directly related to the allegations in the formal complaint, including evidence on which the recipient does not intend to rely, and any exculpatory or inculpatory evidence from any source. Such evidence must be provided prior to the completion of the final investigation report and in time to give the parties at least 10 days to prepare a written response, which the investigator must consider prior to completing the investigation. So that is the one 10-day requirement before the completion of the investigation. In addition to, there has to be the preparation of a written investigation report that fairly summarizes the relevant evidence and provides the report to the parties and their advisors, if any, for their review and written response at least 10 days before a hearing or any determination of responsibility. So you've got at least those two 10-day opportunities for response and consideration. Moving on to hearing, the hearing provision. There are hearing requirements that apply. However, hearings are not required for K-12 schools, at least in terms of providing live hearings. Per OCR's commentary, school officials could determine that their educational community is best served by holding live hearings for high school students, for students above a certain age, or not at all. The OCR commentary also states that a Title IX coordinator could determine whether a live hearing is necessary on a case-by-case basis, provided that the K-12's recipient's grievance process clearly indicates the equitable circumstances under which a hearing will or will not be provided. So K-12 schools can decide to have live hearings in regards to the sexual harassment process, but need to either set a threshold for the age or the level of the student, or determine the factors for case-by-case determination. With or without a hearing, the recipient must provide each party the opportunity after the completion of the investigation report to submit written relevant questions, and that word is key, relevant questions, that the party wants asked of another party or witness, provided each party with the same answers, and provide for limited follow-up questions. So the rule establishes when questions regarding complainant's prior sexual behavior or sexual predisposition are considered relevant in a hearing provided by a K-12 recipient. Next provision is in regards to this determination of a responsibility. So once you've got through the investigation, is there a determination of responsibility for the sexual harassment? The decision maker, who cannot be the investigator or the Title IX coordinator, must apply the recipient's standard of evidence and issue a written determination of responsibility that identifies the allegations that potentially constitute sexual harassment. It has to describe the recipient's procedural steps taken from the receipt of the complaint to the determination. It has to include the findings of facts supporting the determination. It needs to include the conclusions regarding application of the code of conduct of the facts. Has to include a statement of and a rationale for the result as each allegation, including a determination of responsibility, any disciplinary sanctions, and whether remedies to restore or preserve equal access to the recipient's education program activity will be provided to the complainant, and has to include procedures and permissible basis for appeals. In regards to appeals, that's the next provision. The recipients must offer both parties the right to appeal a determination of responsibility and the recipient's dismissal of a complaint or any allegations therein for the following reasons: a procedural irregularity that affected the outcome, new evidence that was not reasonably available at the time of the determination and could affect the outcome, conflict of interest on the part of the Title IX coordinator, investigator, or decision maker that affected the outcome. The grievance procedure may also offer both parties an equal right to appeal for additional reasons beyond these reasons. But the key piece to the reasons that are in the regulation is that the allegation has to be that it affected the outcome, that it did affect the determination of responsibility. Also, in regards to appeals, with all appeals, the recipient must ensure that written notice is provided to both parties of the appeal and provide both parties an equal opportunity to submit a written statement in support of or challenging the determination. The appeal process must result in a written decision that must be provided to both parties simultaneously. In addition, recipients must ensure that the decision maker for an appeal is not the Title IX coordinator, investigator, or initial decision maker, does not have a conflict of interest or bias against the complainants and respondents generally, or the particular complainant and respondent, and receives training as required by the regulation. So that is the appeal provision. Now, in regards to the provision about informal resolution, the regulation prohibits offering to facilitate an informal resolution process unless a formal complaint of sexual harassment is filed. The intention for this is to ensure that the default procedure when a formal complaint is filed includes an investigation. At any point during the formal complaint process, a recipient may offer to facilitate an informal process that does not require full investigation, as long as the recipient provides both written notice of the rights under the regulation, obtains the parties' written voluntary consent, and does not offer informal resolution in the context of a complaint alleging that an employee harassed a student. So those are the provisions where the informal process can be used. One more comment from the OCR in regards to informal resolution is that it, quote unquote, may encompass a broad range of resolution strategies, including but not limited to arbitration, mediation, or restorative justice. Record keeping. Recipients must keep records related to reports of alleged sexual harassment for a minimum of 7 years, including investigation records, disciplinary sanctions, remedies, appeals, and records of any action taken, including supportive measures. Records should document In each instance, the recipient's response was not deliberately indifferent, and that measures were taken to restore or preserve equal access to the education program or activity. If a recipient does not offer supportive measures in response to a report, the recipient's records should document why the response was not clearly unreasonable under the known circumstances. In addition to retaining for the required 7-year period any materials used to train the Title IX coordinators, the investigators, the decision makers, and any employee designated to facilitate an informal process, recipients must also post the training materials on their website, or if there's not a website for the recipient, otherwise make the materials available to the public. So the training materials have to be posted on the website. And this is going to be, could be an onerous requirement. In addition to all the other record keeping requirements that you now have quite a bit of information that needs to be maintained and included in terms of the Title IX process. The final provision that we'll go over as a part of this episode is the retaliation provision. So the rule broadly prohibits retaliation by a recipient or any other person against any person for the purpose of interfering with the Title IX rights, or because the person has participated or refused to participate in any manner in a proceeding under Title IX regulations. Complaints of retaliation may be addressed under the recipient's Title IX grievance process. Couple pieces to address there. Charges against an individual for code of conduct violations not involving sexual discrimination, sex discrimination, or sexual harassment, but advising out of the same facts or circumstances as a report or complaint of sexual discrimination, of sex discrimination or sexual harassment, constitute retaliation if the purpose of the charges is to interfere with any right or privilege secured by Title IX or its regulations. An example provided by OCR is that if a recipient takes disciplinary action against a reporter based on underage drinking with the purpose of interfering with any Title IX right or privilege, this would constitute retaliation. However, on the other hand, if the recipient's code of conduct consistently prohibits underage drinking, then the disciplinary action would not be considered retaliatory. Also, charging a person with a code of conduct violation based on the person's knowingly making a materially false statement in bad faith in an investigation is not retaliation. However, that a determination of responsibility alone is not sufficient to determine that a person made a materially false statement in bad faith. A recipient must keep confidential the identity of a person who complains or reports sexual harassment, including parties and witnesses, except as permitted by law or to carry out the purpose of these regulations. So that gets us through the highlights of the provisions of the different pieces that came out of these new regulations. Now we're going to have the opportunity to give you some high-level checklist components for you to consider to try to ensure that you're in compliance. And so here's our checklist. First, appreciate your continued feedback on the surveys about this episode and other episodes. Also encourage you to continue to participate in our Monday office hours during this professional development series. And that's your opportunity to ask questions about this content as a part of your registration. Be ready by August the 14th. It's going to come up on you fast. You have a ton going on, an unprecedented time to be considering all these issues. But there's a lot to do here, so don't wait till the last second to get this all rolled out. Next item on your checklist, discuss and decide on discretionary portions of your approach to compliance. For example, will there be any circumstances where you will have live hearings? That is not an option for post-secondary, but it is an option for K-12. Another example, what is your evidentiary standard going to be? Is it going to be the low bar of preponderance of the evidence, or is it going to be the higher bar of clear and convincing? So that you have some items to consider there before you lock in your policy and procedures and training, etc. Once you get that figured out, then you need to dive in and update your policies, statements, procedures, notices, and guidelines. Have already started doing that for some clients, and imagine I'm going to get continue to get a lot of those requests. So feel free to follow up with me individually to ask for assistance in that exercise. There are a lot of different players here with this process. So you will likely have to reorganize how you have traditionally addressed non-discrimination, anti-harassment, and definitely specifically Title IX, because you're going to have various people involved that cannot wear the various hats. And once you do that, you're going to have to roll out your training program. Again, I've had requests for assistance with training and plan to do that individually for clients. But you're going to have to get rolling on your training process and reserve some time to get that accomplished. You're also going to have to provide guidance to your students and other members of your educational community. So while the high level and detailed training may be a core group, and it may you might provide a little less information to your staff, but you're also going to have to provide information and notice to all your students and your educational community in some way. There's quite a bit of changes here, and some of them are going to be a surprise, so good to let them know up front. Would strongly suggest that once you feel good about all your documents in place, you've done your training, is that run through some hypotheticals, some common ones and maybe a few more severe ones, and determine how you might handle those. I think that will be a very useful exercise, so that you're not thinking through this for the first time when the real allegations come to you. And also realize this is going to be a learning process. Strongly suggest that you do some debriefing after each one of these allegations and figure out whether anything should be tweaked and should be updated. So strongly consider that you keep yourself flexible a little bit before you get comfortable with this, so you can get comfortable with the end process. And all this being said, realize that these are regulations and they can be superseded by congressional action, and they also can be changed by future administration. So if we have a new Secretary of Education, we have new priorities come 2021, then be prepared for some changes to be made and some of these things to be rolled back and other things to change and go in another direction. So a lot to consider here, but just wanted you to be prepared for that possibility. With that, understanding that this was quite a bit of information for this episode, but hopefully it gets you started in the right direction for compliance. And one more reminder to update your contact information with at least my new email address and continue to use my traditional cell phone number. And with that, please have a great rest of your day, your week, your weekend, wherever you are at, and certainly have a good rest of your summer. Take care.